Good morning, everyone. Welcome to Access to Justice, Equality, and Business of Law. I think many of us in the audience today are very interested in some of the structural changes that have been happening in the legal profession and how law is being practiced, particularly in the private bar or the private business of law. And particularly the impact that gender has on various issues like financial compensation or opportunities, opportunities like career advancement, and retention rates or movement and exit from the legal profession. And these are a few of the topics that we want to explore this morning in the context of private legal practice or the business of law. And to engage in this dialogue, we've got a great lineup of speakers this morning coming from both East and West, which is kind of nice. So I just want to take a couple of minutes and introduce the speakers to you. Anita Anand will be joining us by Skype. And so you're going to see her lovely, her face on the on the big screen. Oh, there she is. There is about a 20-second time delay, I'm told. Anita is a professor at the University of Toronto, and she is the director of the Center for the Legal Profession and Program on Ethics in Law and Business. Her scholarship focuses a lot on corporate and securities law as well as ethics and the corporation. And since 2010, she has served on the Chief Justice Ontario's Advisory Committee on Professionalism and was appointed to the Bertha Wilson Honor Society by the Schulich School of Law for service to the legal profession. And as I said, she'll be joining us via Skype, and we'll be hearing from her about the constraints facing women in private legal practice and providing us with a bit of a cost-benefit analysis in that respect. Beth Symes at my far left. She practices with the Toronto firm of Symes, Street and Millard, and I guess it probably goes without saying that Beth is very well known for the case that she took all the way to the Supreme Court of Canada, challenging Revenue Canada's policy on deductibility of childcare expenses as or disallowing them as business expenses. And so we are I guess, grateful for her to bring some of these equality issues, not just in talks to the profession, but also to the courts and to have those heard. Her entire career has been one of incredible involvement with equality issues and the legal profession. Her resume, you know, it goes on for days, but she was a founding member of LEAF, which I think we can all appreciate, founding member of the Feminist History Society. She's been a member of the Order of Canada since 2011, and that same year was recognized by Canadian lawyers as one of the 25 most influential people in the legal profession. She's also very involved in Ontario with the legal profession, and I believe we're going to hear more about that involvement, particularly as it relates to the Justicia project, a project of the Law Society of Upper Canada that's designed to both retain and advance women in private practice. So I look forward to that. Andrew Pillier is a PhD candidate at UBC. His research tackles very important issues of access to justice and career satisfaction of lawyers. And not surprisingly, then his master's thesis, if you have the opportunity to read it, it is online. It explores kind of an alternative business model for private practice, an innovative model that's more focused on trying to advance social justice causes and service people that can't afford legal services rates. Andrew was one of 20 people chosen to participate in Action Canada, a leadership and development public policy program, which is a feat in and of itself. Andrew's also, if you have the opportunity, he was a finalist in the 3-minute thesis at UBC, which I think is just remarkable. If anyone can get their point across in 3 minutes, obviously I can't, but I think he's just done a wonderful job. And he actually just told me that he's actually just recently recorded a TED Talk. It's not been released yet, but I think we'll all be waiting to hear that in the future. So that's great. I know he will be talking in the course of the morning about factors dealing with career satisfaction among lawyers and as those relate to the private practice. I also want to introduce Beth Bilson from the College of Law, although she probably needs no introduction. She's well known for her scholarly and professional work in the areas of labor and administrative law, as well as being a legal historian, a preeminent legal historian. She's the former dean of the College of Law, past chair of the Saskatchewan Labor Relations Board, a very active member in the Canadian Bar Association, and has been a wonderful contributor to our university. And for those of you that don't know, she's currently co-chairing the Transform Us committee here at the university. So the fact that she could come here and isn't in another meeting is quite remarkable. Beth is a bit of a latecomer to this panel, and I want to thank her for joining us on short notice. You will see from the original advertisements for this panel, we had intended to have Fiona Kay, a sociologist from Queen's University. Fiona has authored numerous papers, conducted significant empirical research on the legal profession, and particularly women in the legal profession. And unfortunately, for personal reasons, she was unable to attend. So I have asked Beth to come. Beth and two of her colleagues in sociology, Susan Robertson and Elizabeth Quinlan, have recently authored a report for the Law Society and CBA and Law Foundation, looking at a comparison of experience of women in the legal profession in Saskatchewan with their experience in Canada. And because it is short notice and because Fiona isn't here, I was asked to try and bring some highlights out for you to kind of kick off this panel to kind of demonstrate or at least bring some information to you that I hope Fiona would have brought and Beth's study has unfolded that looks at factors that are influencing retention of women in private practice law firms. So without further ado, I think I'll take this opportunity to move into that, and then we will hear from the other panelists, and then we'll have some time for discussion and questions. Oh, there we go. Okay. So what has been happening in Canada to private law firms? I think we understand that if this panel is about the business of law and the practice of law in private firms, what is the Canadian experience? I don't think it's any surprise that what the research is finding is that there has been an increase in the number of larger law firms. I almost call them the mega firms, and a decrease in solo practice. This has also resulted in increased specialization and fragmentation of legal practice, maybe a decrease in the generalists and an increase in specialization. What we're also seeing is a significant increase in mobility between firms and other legal practices. This mobility has also seen increases in people moving out of private practice and seeing significant numbers of lawyers working as in-house counsel in university, in the public sector, or moving to judicial appointments. What is the Saskatchewan experience? If Canada overall is seeing this increase in large firms, the Bilson, Quinlan, and Robertson report that has really just recently, has it even been released, Beth?
Well, barely.
It's barely been released, I think maybe 2 days ago or something. So this is really the first time you're seeing some of that. This is a bit counter to the Canadian experience. What we have seen is that large practice in Saskatchewan is still staying at around 2% of private practice firms. And there's actually, we've seen an increase in solo practice firms, which is a little bit different than the trend in in Canada. We're also seeing kind of a decrease in size of mid-level firms as well. So what size of firms are women in private practice practicing in? On a percentage basis, if we look, this is a comparison of Saskatchewan, Alberta, Ontario. The percentage, I guess, overall of women in private practice in solo practices seems pretty similar. In Saskatchewan, we have slightly higher rates for women in 2 to 10 person firms, and a greater percentage in 10 to 50 lawyer firms. The percentage, it does say there were 0 women practicing in firms over lawyers. I think that's a 0 percentage, so it was under 1% where that was occurring. Okay. In terms of where are women practicing, we've got a bit of a comparison here between where women in Canada are practicing and where women in Saskatchewan are, or what parts of the legal profession they're moving themselves into. You will see that as a percentage basis in Saskatchewan, there is more women proportionally in the public sector than there is kind of nationally, and more women in the judiciary. This is a snapshot of income by practice for comparing men and women, and this is taken from 2006 census data, so it's not completely up to date, but it's the best data available. So this is a snapshot based on 2006 census data, and you can see the comparisons, particularly in private practice, in terms of wage disparities between women and men. This is also a snapshot doing a comparison into giving 2006 census data of Canada and Saskatchewan income comparisons. So we can see where in the public sector, or pardon me, private sector, based on Canada and Saskatchewan, doing that comparison, that women continue to lag behind both nationally and provincially. This also, based on census data, looked at full-time and part-time work stats by type of practice in Saskatchewan. This was kind of interesting. If you look at kind of in terms of absolute numbers, this isn't a percentage, this is absolute numbers that we have. Based on the census data, the information that was coming out showed that in terms of legal services in private practice, we see that there is a significant number of men and women both working full-time. There is the rates of part-time work overall for men and women in the private sector practice are similar, but as a proportion, we see that women tend to take up the practice, if they're in private practice, more frequently on a percentage basis, on a part-time basis. Part-time or part-year, I'll say. So one of the big questions then for private practice firms is, why are people, and in particular why are women, leaving or moving out of private practice to other legal positions? And this is important for a few reasons. First, from a cost perspective, if we look at high turnover rates in firms, they are associated with higher costs to the firm, to the business. They have increased recruitment development costs, missed opportunities within the firm itself. Instability is cited as a problem, disruption to relationships with clients in terms of servicing clients, and loss of proficiencies. In terms of personal costs that people face when they are leaving the profession or moving within the profession, there is also high personal costs for the individual. And servicing the high costs of higher education has been noted as a problem. We recognize that tuition and cost of living have increased significantly, and students are graduating with high debt loads and having to service those debt loads. The results also are disruption and change of earnings, disruption and change in career advancements when you're moving or exiting the profession. And then if you do exit and then are trying to come back, there are barriers to reentry. So both the personal and business costs are high. So to date, when we have looked at this question, we often, or some of the research, I guess, to date, has looked at reasons that have been identified for women leaving the private practice. And some of that that has been identified as dissatisfaction with promotion, motherhood, and issues of work-life balance. And some of the most recent work on this question of mobility, retention, and exit, or leaving the profession, has been done by Fiona Kay and others. There is a really important report that has been released, and if you look at the Law Society of Upper Canada website, there is a significant report that she has co-authored, and there's other papers that are forthcoming that we've had access to in relation to that report. So she conducted a kind of long-term study looking at various factors, but various factors of private practice, and focusing on mobility and exiting from private practice in general. And this study that she did engage in looked at over 1,600 lawyers in Ontario. So it is Ontario focused, but it's not surprising given that it was commissioned by the Law Society of Upper Canada, and also that such a significant portion of our legal profession is concentrated in Ontario. One thing that was interesting is just in terms of overall within the profession is that there is greater or increased mobility. If you look, doesn't look like the little pointer is working. This nice little pie there suggests that 6% of people actually don't move. They just stay, they land their job, and they stay in that career path for the rest of their lives, or rest of their working lives. That's kind of interesting, because I think there's an assumption out there that we tend to stay where we start, and in fact, there is quite a bit of movement within the legal profession, where you have at least two jobs, 3 jobs, 4 jobs, or up to 5 or 6 more. In terms of overall, we do recognize that almost 50% of lawyers surveyed experienced also some career interruptions. So even though they may have been practicing, they did take some type of leave during that practice. The average length of career interruptions we see is different for men and women, and the reasons for the career interruptions that were identified are also different. Men leaving because they were unemployed, like layoffs, travel, higher education, women, childcare, and then the second being elder care that was identified. In terms of general, in terms of overall lawyers leaving the profession based on case study, we do see that approximately 44% of all lawyers that start in private practice leave private practice. 66 remain. But are those rates evenly distributed? It looks, based on this data, that women who start in private practice, 52% are leaving, and 35% of men leave private practice that start in legal practice. Now, I did use the word leaving because leaving does include movement to other legal professions, so this doesn't necessarily mean exiting the legal profession, but much of that movement happens within the first 5 years of practice, and the rates are different for men and women. So, what are factors that increase the likelihood of leaving private practice? Well, poor economic conditions, of course. Taking a leave from the firm. In some of the more recent, or the recent study that Kay has done, she's looked at some of these variables. And one that seemed to be significant was this idea of taking a parental leave, that parental leave had a significantly greater effect than any other leaves if you take a parental leave. And this is a gendered variable, given that only 4% of men are taking parental leaves, so the majority of parental leaves that are being taken by women. Another factor that was also important was experiencing sexual discrimination. It's a gendered variable. Again, only 11% of men reported actually experiencing sexual discrimination. Another thing that was interesting was men's leaving rates decreased with the number of children that they had, and women's progressively increased. Maybe that's not a surprise. And so I asked this question, is it the consequence of parental leaves and the impacts upon return, or is it the children? Is it actually the children, or is it the impact that women are feeling upon coming back to, and maybe that's a question for discussion. And so I've raised some questions even at this point in terms of issues to investigate. How are women treated upon return from parental leave? Are they disadvantaged in terms of clients, assignments, support? Are they viewed as less competent when they return from parental leave? Are they held to higher standards than their male colleagues when they return from their leave? And are they viewed as less committed to the firm upon return from parental leave? Okay, so those, I think, are issues that maybe need to be investigated. And there's other gendered factors that increase leaving rates, long work hours, and interesting, a smaller firm size, which I can't explain, but it was in her results. So this is factors. So we often talk about, what factors result in leaving. Well, what results in retention? What factors are positive or decrease the likelihood of actually leaving the profession? And some of the things that were identified were people that practice people law, that as compared to what we would say corporate and commercial law, non-people law. I guess it's all kind of people law, but the idea being people law is a little bit different. Landing that ideal job after law school. If this is what you always wanted to do, that's important. Early success in client recruitment, this was also a gendered variable. If you have early success in client recruitment, there's less chances of you leaving private practice. There is a issue here, though, because women are less likely to have primary responsibility for bringing clients into the firm, particularly early in their career. So client development isn't something that women are doing early on in their careers. Workplace with flexible full-time schedule, that was also important. One of the things that has come out in the information is that it's slightly more significant for men, but it's still significant for both. And then satisfaction with power track or career advancement and financial compensation. Is Saskatchewan different? Well, Saskatchewan is slightly different. We do tend to have high mobility, consistent. The survey that Bilson, Robertson, and Quinlan did ask questions about leaving for the profession. Interestingly, if you look at the percentages that are there, they were very similar for men and women. There wasn't really a big difference in terms of reasons that were given. Actually, women were cited, work-life balance, which is typically the one that we look at. Women were saying that about 9.5% of the time it was work-life balance, and men were saying it was about 8% of the time. So that I thought was kind of interesting. One thing that seems to be fairly consistent is women leaving the practice, 25% left within 4 years of practice, so in the early stages of practice, and 30 left within 5 to 10 years of practice. And there's various reasons that have been identified as the reasons for leaving. Denied opportunities for career advancement, types of work assignments, inability to meet the billable hour expectation. This is interesting, inability to meet the billable hour expectation because of childcare demands, and that was kind of cited as the reason being that there's an expectation to work overtime, and when you have to pick up your children from childcare, you can't work overtime to meet those targets, and there is still the expectation that even if you are pulled full-time, part-time, that you still have to do all of the non-billable requirements as well. So these are factors that have increased. And I think we'll leave this with a big question. Given the factors that lead to exiting or lead to retention, what can we do to actually stem that tide of exit and retain these retain women within the profession. So thank you for letting me present some of Kay and Bilson's work. And I'd like to now take the opportunity to turn it over to Beth, or to Anita and Ann, who are going to bring up via Skype.
Heather,
Oh, sure, sure, yeah.
I'd like to thank Heather for putting all this together because, you know, as she said, this is a study that I was involved in, but I didn't really have time to prepare for this meeting. But I would like to make a couple of comments about the study. One of the things that I thought was interesting about it was that this was a replication of a study that was done 20 years earlier, and for that reason, I think it produced a lot of very interesting comparisons between what was going on in 1991 and what was going on in 2011, 2012. But I think one of the interesting things that came out of it was the apparently lower level of preoccupation with gender as a salient issue. That is, the response rate was lower, and there are many reasons for that. I think people are sort of survey numb, really. You know, everyone gets 7 Survey Monkey invitations a week. And I think that certainly was one of the reasons. But when people were asked about that, they said, well, gender just isn't as high profile an issue for us. Now that you know, that observation is interesting and I think requires more investigation because obviously I think the kind of information that Fiona Kay has put together and that came out of our report sort of indicates that there still are differences between the way women experience practicing law and the way men do, and in the opportunities that are available for women. So I think that's an interesting issue and needs to be pursued a bit. I mean, I'm not sure whether, and I think going back to some of the things that Susan said yesterday, that you know, the kind of reaction that feminism is sort of an old-fashioned idea and that we've cracked it and, you know, there's nothing left to accomplish. I think the statistics suggest that isn't the case, but that orientation, I think, is worthy of further exploration. I think the other thing that I just wanted to flag that was interesting in our report, and this kind of makes sense if you think about it, given the evolution, but the figures for the legal profession in Saskatchewan, and I don't imagine they're much different everywhere else, indicate women are now half the profession in Saskatchewan, more or less, and half of those people half of the women in the legal profession are under 40. A quarter of the men are under 40. And that suggests that there's sort of some big changes maybe coming. I mean, unless women just leave. And that's, I guess it will be interesting to see whether that happens. But it does seem to me, and I think, as I say, I think that's likely to be the picture across the country, that there are a lot of young women in the legal profession. And I think in many ways that's a basis for changes in what's going on. So, thank you.
And all right. And Anita, are you there?
Yep.
Wonderful.
Yep.
Without further ado, Anita and Ann from the U of T.
Thank you so much for the opportunity to speak with you today. I'm sorry I'm not there in person, but I can see myself on a screen, which is a little bit daunting, so in a way I am there. I have been asked to address economic constraints that may stand as barriers to access for women and visible minorities. I just wanted to mention a little bit of my own personal background. I'm an academic at U of T. Prior to that, I was at Queen's. Obviously, I'm a woman and a visible minority woman at that, and I did practice in a large law firm prior to becoming an academic. So I come at this issue from a number of different vantage points, and I'm really pleased to be able to speak to the issues of costs and accommodation, which I'll address towards the end of my remarks. So the three main points I want to focus on today are law school tuition issues, systemic discrimination in law firms, and then what is it that law firms can and should be doing in terms of recommendations that we can be thinking about. So first, law school issues. Well, we know that law school tuition is high, higher in some schools like my own than others. And certainly this raises the question of whether tuition itself is a barrier to women and visible minorities entering and remaining in the legal profession. Now, the Ornstein report does not provide data on law school admissions. It does provide some relevant data about young lawyers out, as previous speakers were touching on. At our own law school, however, our class over the last 3 years averages 50% women, so that's in keeping with the type of statistics we've heard thus far, and 35% visible minorities. But the question of cost still persists, and I would say that the research is lacking in Canada on law school admissions, and more specifically on the interaction between law school admissions and loan programs. So the questions that I would see to be relevant here are who is targeted through loan programs, how pervasive are these programs, and are we targeting socioeconomic status alone through loan programs? Now, admissions numbers depend on loan programs to some extent, especially in law schools where tuition is disproportionately high. And admissions may also depend on the next subtopic that I'd like to touch on under law school tuition issues, and that's on the expected earnings following law degree, and on the rationale that this is relevant because prospective students may wish to ensure, and one would hope that this is the case, that they can repay their loans. So turning now to this second subtopic, one reason that lots of people enter the legal profession is because it pays well. There's compensation, there's remuneration to be counted on, generally speaking. But note that the Ornstein report says that women and racialized lawyers earn significantly less than men and white lawyers. And so from an economic perspective, this makes a law degree a less attractive investment for women and visible minorities. However, according to this line of thinking, we should also expect more males than females to enter the profession, while in fact this isn't true anymore, and certainly our admissions numbers are evening out at the 50% rate. So in my mind, when I put all of this together, there's still some unanswered questions regarding accessing legal education and remaining in the profession for women and visible minorities, including visible minority men. We need more research here. So turning to the second point that I wish to address, and that relates to systemic discrimination. And I here draw on a study by Huang. It's an older study, 1997, but still relevant. Now, within firms, Huang found that wage differentials between men and women at law firms occurred within as opposed to across practice areas. So what this means is that it's not the case that women are working in less profitable legal areas, but that men are out-earning women in all areas. And Huang found a large premium for working in litigation, but a negative impact of being female, resulting in female litigators being paid the same as male non-litigators. Women are not only less likely to make partner, but to receive smaller income premiums if they do. And again, if I'm trying to put this together, women may leave private practice more than men, perhaps because they get paid less, causing fewer women to be hired prospectively, or to expect to receive a lower salary because perhaps the employer law firm believes that women are more likely to leave. And this brings us to the Kay report and Beth Bilson's work that we just heard about, which, again, to reiterate some of those points, women leave a lot more than men. And when they are in the firm, they're often left off complicated files and overlooked by possible mentors. They're less likely to be involved, Kay found, in recruiting clients and representing corporate clients, and this is correlated with leaving private practice. So Kay shows that experiencing discrimination is correlated with leaving the profession, and she further shows, as suggested earlier, that having children makes men less likely to leave, and I was very interested to see and pleased to see the numbers of children making a difference here, and women more likely to leave the practice. Now, what about reentry? And I want to here bring in work by Gabrielle, who did some work in U.S. firms on visible minorities. And Frederick Gabriel found that minorities are being hired at law firms in acceptable numbers, but are not making partner, often because they leave the firm before they have been there long enough to be considered. And so in looking at why this was the case, he found that visible minorities feel overlooked on coveted assignments. They sense that white partners are uncomfortable working with them, and many leave because their predecessors have not made partner. And so they face the same catch-22 as women. They look ahead and they see that there's a lack of minority partners, which makes them less likely to stay because they see themselves as potentially failing for extraneous reasons down the road. And so what I'd like to bring to the table here is my take on the economic perspective of what we could call opting out of the profession. And I think you can look at lawyers' employment choices as a cost-benefit analysis. It's not the only way to look at it, but because of what I've been asked to do here today, I thought it would be at least relevant to bring this type of analysis to bear. One explanation that is often given by economists for why women opt out or choose less demanding jobs is that they have a preference for non-work activities in the professional setting. So they have a preference for raising children. Now, I personally don't see a problem with choosing that life decision, that choice to raise your children and leave the profession, if men and women have the same benefit from continuing to work, but different preferences for opting out. But the evidence, especially that we've seen today and that I've looked at prior to coming here, shows that due to discrimination, systemic discrimination, women are less likely to make partner, make less money, less likely to be given interesting work, to be involved in coveted files, to be involved in client activities. And in their view, understanding this, there is not the same benefit from remaining in the profession. For many women, to stop practicing law may be inspired by the lower expected value of remaining in the practice as much as it is a preference to have an opportunity to spend more time with their children, to go back to school, or to change professions. And so I guess one of my main points here today is until we even out the benefits of remaining in practice, we cannot attribute the choice to leave practice as one simply relating to the desire to raise children alone. We need to work on evening out the benefits that accrue to professionals remaining in the practice of law, whether they're men, women, visible minorities. So turning then to my third and final point, I'd like to talk about what's going on within law firms in terms of working with women to allow them to raise their children and continue with the practice of law without presenting the options as being black or white. You must either participate in the practice as it has traditionally been, or you don't have a place here. And of course, I'm painting that picture a bit more starkly because, as you know, many law firms would agree that there's a benefit to retaining women and visible minorities, that their law practice is internationalized, that they have clients who speak many languages and who exist in many different countries. And so many law firms, generally speaking, would say we think it's very important to have a diverse demographic own internal structure within our law firm population. However, law firms, generally speaking, don't have an institutionalized accommodation mechanism for women. So if women want to have or approach the partnership requesting an alternative arrangement, it's generally speaking done on a one-off basis, a request, a plea to have some type of flex time arrangement or part-time arrangement, or full-time arrangement with some flexibility in the schedule. And so this need to make the request on a one-off basis is, in my mind, a huge problem because there's a lack of institutionalization that's in place for women as they come up through the ranks in the law firm setting. And I remember when I was practicing, one of the things I wished for most was more institutionalization. I wished for a daycare in the lobby of my building that I could drop my kids off and take the elevator up to work, and then at the end of the day come back and get them or visit them at lunch. These are the types of institutional arrangements and almost innovative thinking that I think is very, very important for retaining women in the legal profession, and increasingly men as well, as they generally take on more of the child rearing responsibilities, including taking parental leaves, etc. Now, of course, the Justicia project is very important in my view, but it's set to come to an end, and we really need to be thinking about more innovative ways of institutionalizing these types of arrangements. So to conclude, I think there's excellent recent empirical work in the field. I'm really pleased to be seeing the work from Beth and Fiona, but the empirics do not answer all the questions, and in particular, why, given the benefits of maintaining a diverse demographic in the law firm, many law firms do not ensure equal access to benefits, retention, corner offices, etc., for women and visible minorities. Now, when I started practicing in '94, and I stayed at my firm for 3 years before entering academia, I had an opportunity to work with Mary Ebert on a project relating to women in the profession. I wrote a letter to Alan Rock, who was treasurer of the Law Society, raising some of the points that I've mentioned here today. And I guess what I would say is that it feels strange to me that I'm still asking the same questions 20 years later. And I'm wondering, just to reference Sheryl Sandberg's work in her book, Leaning In, I'm wondering why women have to lean in and are encouraged to lean in, when I would say that while I'm pleased to do that, I think that our profession and actors within our profession need to lean in themselves, and somewhere in the middle we should be meeting. Thank you.
Thanks very much, Anita. Anita is going to be remaining on the line, if, so to speak, on Skype. And at the end of Beth and Andrew's talks, she'll be available for questions during that time period. Okay. So Beth, I'd invite you to take the floor.
So thank you very much for inviting me to Saskatoon. In addition to having practiced in the private sector since 1978, with a small 5-year hiatus where I was chair of the Pay Equity Tribunal, I practice in a litigation boutique, a 3-person litigation boutique practicing labor, employment, and human rights. And what I also bring to today is that for 10 years, I have been a bencher of the Law Society of Upper Canada and have consistently served on the Equity Committee and was chair of the Return to Practice initiative. I was asked to speak only about Ontario. Now, I know, look, I grew up in northwestern Ontario and in Manitoba, and everything bad in Canada happens in Toronto. I acknowledge that. But the Law Society of Upper Canada, otherwise known affectionately across Canada as LSUC, has funded the leading research on women and racialized lawyers in the profession. And we are indebted to Fiona Kay. Fiona Kay, started out working with us as a brand new academic, and then she had twins, and it's sort of like we're growing up together. And I'm part of this 1,600 cohort that she has studied over a longitudinal period from lawyers called from 1976 to the year 2000. We're also incredibly indebted to Professor Michael Ornstein from York University, who has done the detailed, hard crunch numbers on money and the population. The data that we have on Aboriginal and visible minority lawyers is much less robust. And so as I make my presentation on both women and on racialized lawyers, please understand the limitations that we have with respect to racialized lawyers. Partly it's a question of self-identification. I think, though, it's also a question that we don't want to count and that we haven't been pushed to account in the same way that we have been pushed with respect to women. So let's begin. Now, some of it will be repeats. In Ontario, for at least 20 years, 50% or more of the calls to the bar have been women, as high as 55% in the years 2000. Women article in the same places as men. 33% in firms that we call big firms, larger than 50. 25% in medium-sized firms, and 17% in the public sector. Most of the articling positions are in Toronto and Ottawa. The others are round-off error. And women are hired back in the same proportion as men. Women are now 40% of the legal profession. They're young. 43% of women are under 40, but only 25% of men are under 40. The other side, 51% of men are over 50, but only 27% of women are over 50. Women are less experienced than men. 47% of women are in their first 10 years of practice. 25% of men are in their first 10 years of practice. And how about women in leadership? Well, this is the good news part. Well, look, aren't they gorgeous? 3 of our 7 law deans in Ontario are women. Our chief judge of the Ontario Superior Court, Heather Smith. The chief judge of the Ontario Court, Annemarie Bonkahlo. And our Chief Justice, Warren Winkler, retires at the end of this year, and there are some fabulous women candidates, one of whom I'm hoping will be chosen. What about racialized lawyers? Well, let's look out of how many is the key. Well, 23% of residents in Ontario are visible minorities. 2% are Aboriginal, So if I use the term racialized, I mean to include Aboriginal and visible minority. This is a term of Statistics Canada. Okay, overall then in the profession, 19% are racialized lawyers. But you'll see from the top down that the percentage of racialized lawyers has really increased. And listening to Anita, where she describes what a law school classroom at U of T looks like, this is now just a few years behind in terms of the calls to the bar. The face of the legal profession is changing. Now, Aboriginal and visible minority lawyers are young. 58% are under 40, as opposed to only 32% in the profession. They're less experienced. 53% of Aboriginal lawyers have less than 10 years in the practice, and 66% of visible minority lawyers have less than 10 years, whereas only 36% of the profession have less than 10 years in practice. Okay, that's the good news. Maybe I should just stop here. Okay, how about the not so good news? Although women are 40% of the legal profession, they're only 32% of private practice. Instead, women are found in government, as in-house counsel, on boards, commissions, and tribunals, and in legal clinics. So what's the difference as to where men and women practice? How about in terms of partnership? Well, only 8% of women are partners. 21% of men are partners. How about employees or associates? Well, 20% of women are employees or associates, but only 15% of men. Is that reflected then in the fact that women are less experienced, younger? Perhaps. What about government lawyers? Well, 18% of women are in government, but only 10% of men. So the career paths of men and women are very different. How about income disparities? And this is the work of Michael Ornstein, based on the 2006 census. I'm unclear as to whether or not this research is going to be replicated in the recent census because, of course, the long-term census was abolished. Okay, in the beginning, women earn approximately the same as their male classmates. So when you look at income, it is incredibly important to hold year of call constant, right? You've got to compare apples and apples. You're not to compare a woman who's just been called with a male cohort who has 30 years of practice. That isn't helpful, and it isn't helpful to average because of the lumpiness of women entering the practice. Okay, so after call, there's slight difference. They are not statistically significant. But what about after 5 years? You see, I'm not so good at these PowerPoints. Please excuse me. After 5 years, women earn 20% than their male classmates. Holding year of call constant, after 5 years, there is a 20% gap. And after 10 years, there's a 28% gap. And that gap continues to increase. So there is huge disparity between what women earn and what men earn. What's the impact of children? I think we've seen that. Women with children earn less than women without children, and the gap's increasing. Men with children earn 10 to 15% more than men without children. I heard the thesis that men without children are unstable. whereas men with children understand that they have to contribute. What about women and men? Women are less likely to be married than men. Isn't that interesting, eh? 31% of women partners are not married, but only 8% of men partners are not married. Women are more likely to be separated or divorced. These are women lawyers, okay? 24% of women are separated or divorced, but only 6% of men. Women are less likely to have children. 66% of women lawyers have children, and 84% of men. Interesting, eh? And what about leaving practice? This has been described in the two previous speakers. Each year, more than twice the percentage of women leave private practice than men. Each year, 5.2% of women leave, and only 1.9% of men. Each year, more than 3 times the percentage of women leave the practice of law altogether. 2.3% of women and 0.7% of men. You know, I don't actually care if women leave Bay Street and go to government, etc., but I am concerned when we lose women to the profession, totally. Why do men leave? Well, surprisingly, they leave to retire. This is the largest reason why men leave the profession, to retire. To go into business, to go into politics, to do exciting things like sail around the world. I meant that facetiously, but those kinds of activities. And what about women? Women leave to care for children. Because, Fiona's K, women bear a disproportionate share of childcare responsibilities. And women continue to be children continue to be the single largest barrier to women's participation in the profession. A 2010 study out of Temple University shows that taking a 1-year maternity leave decreases women's chances of being made partner by 33%. And that taking a maternity leave of 1 year decreases women's partnership earnings by 28%, and that's forever. Like, it's not that it's in the year that you took off the maternity leave, your income went down. It is a permanent, irreversible gap. Now, what about racialized lawyers? The picture's not great. Only 6% are partners. 21% are employees or associates, and 20% are lawyers in government. Racialized lawyers earn less than white women, and they earn significantly less than white men. What about judicial appointments? Do women make a difference? I disagree with the Honorable Marie Deschamps in her comments last night. In my tax case, the court split 7-2. The men against, and the 2 women said, of course, of course. I think women make a huge difference at all levels of court by bringing their perspective to the issues, on the issues that are before them. Okay, what's the qualification? It's 10 years called to the bar. Well, if we've had women for 20 years at 50% or more, the pool of qualified candidates is rich. The appointments vary widely from court to court to court. So the court in Ontario, its pretty well reflects the number of women and racialized lawyers in the profession. Not perfect, but through successive governments, this has been a priority in terms of their appointments and the way that they do the appointment process. Now, what about Prime Minister Harper's appointments? They have been overwhelmingly white men. And on average, 5 years older than the Chrétien Martin appointees. I addressed the new judges training program, 50 new appointees, 4 of whom were women, not a racialized person in the room. And last night when I couldn't sleep, Janet, I looked at the Saskatchewan Court of Appeal. 1 out of 6 women. Justice Georgina Jackson is the only woman on the Saskatchewan Court of Appeal. And you know, if you look back in the archives, 3 out of 7 were women on the Court of Appeal just a couple of years ago. And then I went to the government website and I looked at the appointments for Saskatchewan. There's been lots of vacancies. You know, they've all been filled by men. Interesting. 1 vacancy. How much pressure is there to appoint a woman? So, what has the Law Society of Upper Canada done on this issue? Probably not enough. So for 20 years, we have funded fundamental research, which gives us the numbers. It's no longer helpful to talk about myths or personal experiences or, you know, I didn't realize there was a problem, etc. We need to know the numbers. It's only if we have the numbers will we, in fact, be able to push for change. We've heard about Justicia. What is Justicia? Justicia is a program that the Law Society initiated. It was for keeping women in private practice. It is addressed exclusively to medium and large firms. It has developed absolutely first-rate maternity leave policies, part-time policies, etc., and has developed best practices to encourage women to rainmake. But, here's the huge but, there is absolutely no evidence that it has made any difference as to how women are faring in the profession. It is voluntary, there is no accountability, and it's not clear that it has had any real impact or change. It hasn't in any way slowed the rate that women are leaving private practice or even the practice of law. And in fact, after 5 years, many women aren't at these Justicia firms at all. And the principal reason is that the responsibilities for childcare are just incompatible with today's 24/7 demands to provide legal services. Okay, so what else have we done? Well, we focused on women in sole practice and in small firms. We define small as 5 or less. And the first program that we did is career coaching. And by the way, we borrowed it from Manitoba, which pioneered this program in Canada. So it provides, the Law Society pays for 6 hours of coaching. 2 hours before leave, 2 hours during leave, and 2 hours after the return to practice. So before leave, the coaching is focused on is how are you going to transition out? Who's going to look after your clients? Might it be a good idea to leave room for you to return, as opposed to handing over your clients to a young man? During leave, should you have a complete break, or what about keeping connected? keeping a toe in. I haven't left yet. And then to talk about how to go back. And after return, the challenges of ramping up a practice again and balancing work and family. This program is in its infancy. The women who have used it have reported fabulous results. I think that this is a program that every law firm should offer if they're serious about wanting to keep women. What about the parental leave assistance program? It's, again, only for small firms and sole practice. Its goal is to assist women to stay in practice after a maternity leave. It provides $3,000 a month for 3 months. And the women use that money to pay their overhead while they're off. It's been a huge success. It has enabled women to stay in practice and to return. But there has been this huge backlash. In November of 2012, there was a motion to terminate the program. We organized thousands of women to write in to protest. The CBC featured this as an issue, and we had a Globe and Mail editorial. Whatever are you thinking, Law Society? And the benchers backed down. In October 2012, 2013, last month, again, notice to terminate the program. So all of these things that we have fought so hard to win are at risk. Nothing is secure. All right, ways forward. We think of the underrepresentation of women and racialized lawyers as an equity issue, but it also is an access to justice issue. Women are 50% of the population, but only 32% of lawyers in private practice. So a woman looking for a female lawyer obviously isn't going to go to a government lawyer to represent her. So the representation, the dichotomy between the number of women in the profession and the number of women in private practice is of concern. But let me show you the numbers for racialized lawyers because they're even more startling. In the United States, there is 1 lawyer for every 260 residents. There is some research in the United States that says that that is underrepresentation. But in Ontario, it's 1 lawyer for every 402 residents. It doesn't break down very nicely. 1 South Asian lawyer for every 627 South Asian residents. 1 Black lawyer for every 750 Black residents. 1 Aboriginal lawyer for every 749 residents. And 1 Chinese lawyer for every 755 residents. So obviously, in terms of culture, in terms of language, etc., the racialization or lack thereof of the legal profession is an access to justice issue. And what's more interesting is that these numbers are not necessarily improving. In particular, the number of Black lawyers, or the percentage of Black lawyers in the profession, is less than it was a couple of years ago. So that we are not moving forward. It's not that I'm going to be able to say to you in 5 years, in 10 years' time, these numbers will significantly change. We are in danger of going back. Anita talked a little bit about the changing nature of the legal profession. I want to focus on a slightly different issue. Traditionally, a legal firm looked like what's described as a Viking ship. Some clients billed a lot. Others billed modest amounts. And of course, some were one-off clients. And a full-service law firm represented everybody. Their client mix was diverse with diverse earnings or billings. But about 10 years ago, the national law firms moved to an entirely different model, that of what I call a relatively flat triangle. The goal, obviously, is to maximize earnings, and they have chosen to do so by focusing only, exclusively on high-yield clients, like banks, just as an example. Firms have jettisoned clients who are not sufficiently high yield. Let me give you a for instance. The regulators of professions like nursing or teaching or whatever, that's not a high yield client. Those clients are not prepared to pay $750 or $850 an hour for services. And these large national firms are pruning areas of practice, family, wills and estates, employment, and real estate. Those are where women practice. Those are where racialized lawyers practice. And of course, the impact then is that there are far fewer clients for the firm. And if you are attempting to get your own client base, because Anita says that's the highest indicator of attachment to the legal profession, well, there are far fewer of them, far fewer clients to try and be the rainmaker or key lawyer for. And the clients, the firm's clients are handed down from white, male, senior partner to someone who looks like them. Not women, not racialized lawyers. And there is very little room for women and racialized lawyers in this new model. The American experience, people keep telling me, don't look there, it's too pessimistic. It's not like Canada. You know, we're different. I don't know. I sort of think they're the leading edge, and it's not pretty. Well, under the new model, the number or percentage of equity partners is reduced. And the percentage of non-equity and permanent associates is rising. 83% of equity partners are men. And whether a woman is a partner or a non-partner, she earns significantly less than their male counterpart. And the income gap between partners and others continues to widen. I've said this is, I'm just going to skip through this. What are the alternatives? Well, if after 5 years it is unlikely that women and racialized lawyers will continue to be in these firms, I suggest that we need to re-explore articling and to choose articles where women will acquire skills for alternate ways of practice. I want us to consider the Atlanta all-black firm model. In Atlanta, black lawyers consistently hit their heads against a brick wall. They just didn't make partner. They just were not successful. And so a number of them formed all-black firms. And what's so astonishing, at least as a pessimist, was that black business in Atlanta was amazingly loyal. And these firms thrived, absolutely thrived. They are where, if you are black, this is where you want to practice. This is where the cutting-edge law and economically viable practice exists. Should we try this in Canada? And we need better numbers. In the United States, firms are required to keep really detailed statistics on how men, women, and racialized lawyers are faring. We don't keep them in Canada. The Law Society of Upper Canada says, look, we regulate the individual lawyers, not the firms, and it refuses to seek this information. We know that some Canadian firms collect this information, but they sure aren't making it public. Keep counting. Representation of women in racialized issues is an equity issue, and it's an access to justice issue. Thank you.
Thanks so much, Beth. Andrew, I'd like to call you to the podium.
Thanks, Heather. Sure. Good morning. Off the top, I just wanted to say it is an absolute honor and a pleasure to be here. And I'd like to thank the organizers for the invitation, thank my co-panelists for the really interesting conversations before today and presentations this morning, and thank you for being here this morning. It's great to be here at the University of Saskatchewan on Treaty 6 territory, and I love that it's snowing. I am a winter-starved Vancouverite. I love it. Anyway, I've got salt stains on my boots, and I hope these will stick around for the rest of the winter. I want to talk to you this morning about exploring a law firm business model to improve access to justice and decrease lawyer career dissatisfaction. This presentation draws largely on some of the research I did for my master's thesis a couple of years ago. I'm currently doing a PhD at UBC. So I hope to do three things in this talk this morning, and the first is to set out two problems that I think should motivate change within the practice of law, change in how we organize ourselves, and change in how we shape our business structures. One, we've heard quite a bit about yesterday and again today, which is lawyer attrition and career dissatisfaction. And I won't dwell too much on this because we've already heard so much on this. But if this constitutes a sort of pressure from within the profession to change how we do things, I think there's another and equally as compelling pressure from outside, which I'm sure you've all heard about, and those are problems of access to justice. So I think there's a bit of a push-pull here that should drive us to change how we do things. There are people who are unable to access and afford legal services, and I think this cries out for action. So this leads into the second part of my presentation, which is a case study of an innovative firm model in Vancouver called Pivot Legal LLP. And then the third part of my presentation is just to try and problematize the idea of the divide between law as a profession and law as a business. And I'll come back to this because I think it's surprisingly prevalent both in education, but then also in how we practice and how we talk about what we do. So, the twin problems. Access to civil justice, as I mentioned, this is something that is referred to as a crisis, but it's been a crisis for so long that I don't know that we can actually call it a crisis anymore. I'll go into some of the numbers in just a bit. Lawyer attrition, again, we've heard many of the presentations that have preceded me have itemized in detail attrition problems and the unequal nature of attrition within the legal profession. I think this is a very real problem. And so I suggest that these lead to, as I've said, they should drive some innovation. And if you see a face here that is entirely coincidental, I'm just making sure that everybody's still paying attention. I know it's early. All right. So I won't spend too much time on this because we've talked quite a bit about lawyer dissatisfaction and attrition, but just pulling on some of the work done, in addition to the work of Fiona Kay, another prevalent researcher is Jean Wallace at the University of Calgary. She's done some interesting work, and there's some interesting research out there that suggests that lawyers aren't necessarily, on the whole, more dissatisfied with their jobs than others, but the rate of career dissatisfaction tends to be around 20%. It does get more interesting when you start to break down who is dissatisfied and why. But still, using BC numbers, even if we suggest that there are only 20% of lawyers are dissatisfied with their careers, that's still 2,000 lawyers. So that's something to be concerned about, I think. But certainly the attrition from the profession, and the unequal nature of that attrition is very real cause for concern. In addition to the research that's been discussed this morning, I also want to highlight some very interesting work done by Ellen Schlesinger in British Columbia. She's a former lawyer who is now practicing therapist and counselor, and her recent master's work, which showed that, among other things, drew on research that showed that 33% of female lawyers in BC had left practice within 5 years, compared to 17% of male lawyers. But her research is very interesting because she takes an interview-based qualitative look at why women leave the profession and then where they go. And so if anybody's interested, her name's there at the bottom, but I'd be happy to talk in more detail to you about her research later. It's worth looking at. Women leave the profession 60% faster than men. And this was mentioned, Heather, in your presentation, that small firms seem to be least successful in retaining women. Now let's turn to access problems, and let's try to understand exactly what access problems are. Some of the best research out there in Canada is that done by Ab Curry, who was formerly at the Department of Justice and is now affiliated with the Canadian Forum on Civil Justice at Osgood. His study of thousands of individuals across the country on unmet legal needs indicates that almost 45% of Canadian adults, have experienced justiciable problems, at least one justiciable problem, over the last 3 years. Almost 45% of Canadian adults is almost 12 million people. But the vast majority of those people did not seek legal assistance for their problems, less than 10%. So I think this is a problem. I think this is also, though, in some ways, an opportunity. That is, the causes, the reasons why people don't go to law are complex. They're not just cost, although cost is probably a significant factor. But, and Beth, as you just mentioned, the move of national firms away from certain types of clients, combined with this interest in access to justice, I think says that there may be markets there that could be tapped into by lawyers interested in doing things differently, interested in setting up their practices in innovative ways. So this brings me to Pivot Legal LLP. How many people, just by a show of hands, how many people in the room are familiar with Pivot Legal Society in Vancouver? Okay. For those of you who are not, you may be familiar with some of Pivot's work. They're located, Pivot Legal Society is legal advocacy and society located in Vancouver's downtown East Side neighborhood. They've been involved in such high-profile cases as the Insight decision from the Supreme Court of Canada, more recently battles to improve for standing in the litigation regarding prostitution. Sorry. So, Pivot Legal Society is sort of you can think of them as sort of a nonprofit entity. Pivot Legal LLP is different, although the nomenclature obviously is quite similar. The Legal Society set up Pivot Legal LLP in 2006 as a way to do a couple of things. One, try and raise funds for the nonprofit Legal Society, and another was to try and provide legal services for folks in Vancouver's downtown East Side neighborhood. This is a picture of a street in Vancouver's downtown East Side. This neighborhood is one of the oldest in Vancouver. It's sometimes referred to as the poorest postal code in Canada. And over the years, it's been subject to intense media interest, often depicting tales of poverty and human despair. And the Member of Parliament for the riding that includes the downtown East Side, Livy Davies, has commented that it gets more attention than pretty well any other neighborhood in Canada. So, as I mentioned, Pivot Legal Society, the nonprofit, this is a picture of their website, set up Pivot Legal LLP, the full-service law firm, as a way to try and, among other things, raise funds. They thought, well, you know, we could have a bake sale, we could sell stuff, but we're all lawyers. Why don't we sell legal services to try and raise funds? We know that there are people who don't have access. We know that there are people where large firms are moving away from servicing areas. Why don't we go after that work? And so they did. There were a number of other things that goals that they had, including trying to develop legal expertise and articling opportunities for lawyers interested in doing social justice work, providing a supportive workplace for employees, including adopting a flattened and consultative decision-making model. Originally, they wanted to set up the firm as a cooperative. They weren't allowed to do so. Indeed, completely reworking how legal services are delivered in law firms. So this was idealistic, it was innovative, and it almost worked. I say it almost worked because Pivot Legal LLP operated for 4 years between 2006 and 2010, and there were a number of striking successes here, not least of which is the fact that almost 1,400 clients were served over that period, many of whom likely would not have had access to legal services through other means. The LLP won an award as one of the most promising social enterprises in Vancouver. By their 4th year of operation, they had an annual revenue of approximately $350,000 and 11 lawyers. But, as I said, they were forced to fold in 2010. So my research involved interviews with a number of the people who were involved with setting up and running Pivot Legal LLP, including former advisors, former partners, former lawyers, and former staff. And it's interesting to note that Pivot Legal Society, the nonprofit, has a very high profile in Vancouver's legal community. And as a result, the LLP benefited from a number of mentoring opportunities, a number of advisors, including business advisors. Before they started, they talked to a number of people, got ideas about how to run a business, how to make it successful, and they thought they could do it. As I mentioned, they won an award. And so, you know, one question is, if with all of this support, they weren't able to last more than 4 years, what hope is there for anybody else? I'll come back to this because I think there is hope for anybody else trying to do something like this. I also reviewed their business records and media reports about the firm over the years. So as I mentioned, their key goals were to provide a revenue stream for Pivot Legal Society and also to provide affordable legal services for the community, in addition to providing a hospitable workplace for employees through a flat organizational structure And I mentioned they served almost 1,400 clients over the course of their the firm's life. Why didn't they survive? Why didn't they thrive? Well, frankly, I think they tried to do too much too soon. They tried to completely reinvent the wheel in some ways, not just providing an income stream, but also providing accessible legal services and trying to provide a flat institutional structure. I think some of these goals actually conflicted with each other. That is, if you're trying to raise money for an organization, providing accessible legal services may not be the best way to do that. I think you probably have to choose one or the other. And that upon reflecting after the fact, many of the partners and associates had gone on to start their own subsequently successful firms. And that was one of the key things was, look, don't try and do too much and try and be very focused and disciplined in the things you're trying to do. They also had problems with excessive overhead. They were linked into some bad rent arrangements and incurred debt from the outset that proved a bit of a millstone for them. And finally, insufficient revenue. Now, this was a surprise, and particularly in light of the business advice that they got, which said that, look, you guys can come in, you price yourselves appropriately, lower than anybody else, and you should be able to win business from others in the market, big firms who are charging $300, $400 an hour. If you come in below that, you should be able to win clients. Well, unfortunately, that wasn't the case. And there was also a problem of insufficient practice support for lawyers. They spent a lot of attention on how lawyers organize themselves. They didn't spend perhaps as much attention as they should have on the administrative support, and I remember there were some comments about administrative support being, lack of administrative support being particularly, being a factor in women leaving the profession. And I think that rang true in some of the comments I heard. Here's a quote. Don't read it. I'll read it out to you. This is just, I know it's a lot of text on the page, but this encapsulates the difference between the expectations of the firm and the reality. So this is from one of the former partners. We said, let's assume that every lawyer is able to bill 15 hours a week and our maximum billing rate, which was like $150 an hour. And we were like, oh my God, we're going to be rich. And 15 hours a week is not a lot of billable hours for a lawyer. And we did a market survey, and everybody else is charging $300 an hour, and the scope is reasonable. 15 hours a week is totally achievable, and everything flows from that: salary, administrative staff, and all of that. And everybody around the table nodded their heads and agreed, but you know, most of our lawyers, even in their best weeks, would do 5 or 10 billable hours a week, and the rest of the time was unbilled time. Obviously, this is a problem. It got to the point that instead of providing a supportive environment for their lawyers, and that unfortunately by the end, those lawyers who were still involved were working around the clock. They were working more, they said, than they had in private practice before, and the returns just weren't there. Part of this was retaining clients in the first place, attracting and retaining clients. The fact is that the lawyers who started Pivot were, for the most part, new lawyers. And so I'll come back to this in a little bit, but I think this is interesting because the question, if we're interested in trying to support new ways of doing business that could improve access to justice, could improve career satisfaction, and provide better workplaces for lawyers, how are we going to do this? How do we intend to support lawyers, law students coming out so that they can walk into something and create a workspace that they'd like to work in for a long period of time? Here's another interesting quote, and this leads into the third part of my presentation. This is from one of the associates. She said, I used to hate it when partners at a previous firm would say to me, Associate 3, not this person's real name, as much as it's law, it's a business, and I wanted to strangle them. I'd say, I went to law school to help the world. I would get so irritated. But then as I got going, I began to understand. But it wasn't until Pivot that all those words they had said to me became really clear to me. And then I was like, oh gosh, I can never admit to them that they were right. But it is. At the end of the day, you still have bills to pay, you still have life to run, and the idealism of your 20s starts to die when you want to have things. Now, this may seem obvious for anybody who's been in practice for a while, but I think this is actually interesting. And for law students, for those of us who teach or hope to teach or train young lawyers, I think the disconnect between what legal education includes and the parts that are new learning once you're in practice, I think this is an interesting area to look at. The question is, why aren't we teaching law students about the business of law? That is, why aren't we teaching them about how to run a practice, particularly a practice that could help address access problems? And I mean this not just in the academy, but also once they move into practice. So, this brings me to this business-profession divide. At law school, I remember being told that law is a profession, it's not a business. Being a lawyer is a wonderful thing. It's not like being a plumber. I don't know what it is about lawyers and plumbers, but even in the comments from Michelle yesterday, lawyers and plumbers seem to come up quite a bit. And I don't know how many of you have had somebody mention a plumber to you in the context of legal education at some point in time, but I've heard other stories. It's not just mine. The idea of the profession in opposition to business has been prominent in law since the early 20th century. Here's a quote from Wes Pugh, that the linkage of the professionalism with a rejection of market principles is powerful and enduring. And a quote from Samuel Levine, another writer who's written on this, since the earliest years of the 20th century, prominent segments of the legal community have accepted and adopted the assertion that the law is no longer a learned profession, it is a business. And this was viewed as a bad thing. Often this early 20th century talk was couched in racist, sexist, classist assumptions and efforts to exclude people from the profession. But the fact is that there is much more work and much more research on what law is as a profession than what the business of law is all about. Many lawyers seem to gain ideas about the business of law from their own practice experiences or from contacts with others in the profession, either through family members or friends and so on. But how do those without contacts or firm champions learn about the business of law? I think this has important repercussions, because if you're able to go and set up a firm, set up a practice that speaks to your interests, I think you need to understand how to make that business successful in the first place. I'll close by just mentioning some implications of this line of thinking for access to justice. I'd suggest that access problems appear to represent a significant failure of the market for legal services. There are some areas of conflict which I won't go into now, but if you were to look at particular areas, one of those is a conflict between standardized work and discretionary work. These are hallmarks of professionalism and sort of more economically efficient types of practice. But I think what we really should try to do is make the business of law a contested space. And I don't mean this in an uncritical sense of just teaching people how to do their bills, how to bill clients, but I think critically looking at how lawyers structure their business is important, and taking organizational settings seriously is important. So no academic can end a talk without some outlines for future research, and I have this. If there are any funders in the room, I'll be happy to talk to you later. But I think we need to better understand and conceptualize the market for legal services for those without access, including the role of cost, and understand better why lawyers don't or can't respond to access problems through more innovative services. I think this has implications for legal education, for practice organization, and for legal services funding. And with that, I'll leave it there. Thank you for your time.
Thanks so much, Andrew, Beth, Anita, Beth, both Beths. I would like to open it up to some questions. We have a couple of minutes. We will have opportunities in our smaller group workshops to discuss some of the, I think just fascinating information we've had from these panelists. But if there are some questions, I'm sure people would love to entertain them.
This question is for Andrew. The description you had of pivot largely resembles in a lot of ways the practice that I tried to run for a couple of years. And it's still, the practice has survived, but barely. Are there any resources in existence to deal with, like, are you undertaking this type of study and analysis? Are there resources to deal with the issues that you've raised? Because it's what I'm trying to do. You know, and I went for about a year running large, complex cases with virtually no money.
Yeah.
And we're still standing, but really on a hanging by, or have at various times been hanging by a thread. I'd like it to be viable. I'd like it to be a viable practice model that's based on cross-subsidization. And all the lawyers that I work with want that as well as to, you know, have houses in Toronto.
Things. You're not
children,
20.
And children.
Right.
You know, and children. We all have children. So.
You know, Pivot benefited from some structural factors like grants, low-cost loans, those sorts of things. But I don't know that those were actually helpful for them. I think the more helpful things for them were strategies about what types of clients to go after, who to go after, how to recruit people into your firm to allow you to do effective cross-subsidization. I don't know that there is much by way of formal opportunity for those stories to get out there. I've been actually impressed over the last last day really, hearing some stories of people in the room about how they run their practices. And I think the information about small firms and solos in Saskatchewan is perhaps different from my experiences elsewhere, where people do seem to talk about things. Creating that space for people to share these stories is part of what I'm hoping to try and do with this. And I think there needs to be more of that. I'd be happy to chat a bit afterwards, but I mean, encouraging people to share strategies about how to do this effectively, I think could be of benefit. Is that something that would be of benefit? What do you think?
I think so, yes.
Oh,
Let's
good,
have
okay.
a conversation after this.
Shall we go talk to a funder?
So, Catherine, I've run a Robin Hood legal practice now for 35 years. I looked at those pivot numbers and said, whatever were they thinking?
15 hours.
I can't imagine a day with less than 5 billable billed hours and days of 10 and 12 billed hours at whatever the rate is. I mean, either I'm there doing legal work that I'm billing, or I'm at home or somewhere else. And that efficiency, I actually learned in articling. I remember you come home from the arbitration and you bill it that day. And it's absolutely essential for viable continuation of a public interest law practice. We not only have to pay the rent, etc., but we have to support associates and students and staff. It's not something that we were taught in law school, but it's a harsh reality that you just saw in no matter how good the intentions are, at the end of the day, you have to make a financial go of it. And that means, in fact, being strategic about some of the cases that you choose. I always say I do a lot of pro bono work, but it's all intentional pro bono. Meaning that I try very hard not to take on clients who won't pay, or I try and part ways with them soon into the retainer.
Unless you've agreed ahead of time that they're not going to pay you.
Exactly, but that's intentional pro bono as opposed to accidental or default pro bono. And it's not romantic, but it's reality.
Maybe we can talk some more too, Ben. Thank you.
Really enjoyed all the panelists' presentations, fantastic. My question is also for Andrew. I know quite a few of the people who tried to start up Pivot Legal Society or LLP, well, both of them actually. And one of my questions is, I had heard that part of the problem as well was confusion in the public's mind, or maybe the legal community's mind, between the original society, the more advocacy kind of group, and the law firm. So I just wondered if you found that that wasn't relevant in the end compared to the factors you mentioned or not. But secondly, as I'm sure you know, and I'm just wondering whether you've done any comparison, some of those lawyers have set up, I think it's ethos law something, and they seem so far to be making a go of it. And I don't know whether you've had the opportunity to make any comparisons or think about whether some of their idealism got compromised in however they've restructured. I was just curious because I don't know the answer to that.
Yeah. Let me deal with those in order. Sorry, the first question was?
Oh, the possible problem that there was a blurring.
Right, the blurring. You know, I heard that from a couple of the interviews, but I wasn't able to really corroborate that with any of the other information I had. And so I think it points to a bigger question, which is how do organizations or people choose their legal service provider? There was an interesting anecdote that came out of this, was along with the idea that we'd be able to lower our rates and increase clients, the opposite seemed to happen. And anecdotally, it seems to be the opposite of the classical economic assumption, which is when you decrease your cost, your demand goes up, right? Instead, they decreased their cost and their demand went down. Seemed to go, or they came in at low cost and they missed demand. Now, perhaps that is because they mentioned that, look, people wanted to know that if they had a big thing that they had the best lawyer in town. How do you know that you have the best lawyer in town? We've got the most expensive lawyer in town, right? So the branding may not have helped them, but I'm not sure how big a factor that actually played. I think it was relatively minimal, but sorry. And in response to your second question, yes, and I should say that I am reasonably hopeful that the lessons from Pivot have been applied. People are running successful practices based on some of the lessons about discipline, about focusing, and so on. You know, startups generally in business often don't take the first time, but that's no reason not to try again. I think that's a compelling lesson for lawyers and legal professionals. In terms of compromise of ideals, I think a difference is that compared to the people who originally organized Pivot LLP, I think there were maybe 4 or 5 different ideals, and they mutually compromised each other. Whereas people who tend to be in now smaller practices, I think, could be more focused and more definite about what their ideals actually are. Is it to provide funding for Pivot Legal Society, or is it to provide affordable legal services?
I'm just struck by the fact that we're still debating childcare and what year is it? The Globe and Mail recent reports on the Quebec experience, I think, are just so good. I don't think women as lawyers are experiencing anything different than women in the general population dealing with the access to work based on the unaffordability of daycare. And it just seems to me that if, as a group, we want to really do something important, we could support that call for the national daycare program and affordable daycare so that you have the option of working when you have children. I mean, that's what Quebec has found really with their with their experiment in cheap daycare, that it has really increased the participation rate of women in the workforce, therefore generating more taxes for the society to pay for the daycare. And our profession suffers from that same lack of affordability of childcare, in my view.
Gwen, I just go on to comment with respect to that is that in my infamous tax case, which is usually way too painful for me to even talk about, I was being cross-examined by Mr. Powers from the government lawyer, and he said, you know, Mrs. Symes, you chose to have children. I chose to have cats. At 2 o'clock in the morning, I thought of the perfect answer, thank you, Mr. Powers. But, Gwen, it's still the question, it is still seen as a question of personal choice, right? You made the choice, you bear the consequences. Tough luck. And, you know, we hear about men getting more and more involved in the care of children and family responsibilities. You know, I actually don't see that playing out in law in terms of young lawyers. And so I think we need to really go back to the fundamentals and say it isn't a matter of my choice of children over cats. You know, it is a choice for society. And we've really got to tackle it. Before we went to the Federal Court Trial Division, the government cancelled for yet one more time its initiative on childcare, a national childcare strategy. And we are nowhere. I mean, I just wept when I read that Globe and Mail article because it's been so successful in Quebec. It is now part of the social fabric. There is not a chance, well, I say that touching wood, not a chance that it could be dismantled, even in difficult times. And the fallout has been massive increase in participation of women in work, in paid work, across the entire spectrum. How come we don't get it?